Governor Hochul's top priority is public safety, and in this year's budget, she has set out to make New Yorkers safer by making sure criminal cases aren't thrown out based on technicalities. How? By adjusting a process called discovery, the process of sharing evidence in court cases. Before 2019, discovery laws were not very fair to the people accused of a crime, known as defendants. Defendants often did not learn of the scope of the evidence against them until the night before trial, or felt pressured to take plea deals before ever knowing all the evidence against them. In 2019, key changes were rightfully made to make the system fairer, changes that are supported in large part by Governor Hochul. Now, evidence must be given automatically to defendants instead of them having to ask for it. Prosecutors have to share evidence within a certain time frame, and defendants must see all the evidence before agreeing to a plea deal. These changes made the system fairer, but also led to some unintended consequences that the governor wants to fix. Under the current law, entire cases are often automatically dismissed if a defense attorney identifies any missing evidence, no matter how insignificant. Here's how it happens. Defendants are entitled to a speedy trial, and the laws require prosecutors to turn over all evidence within a certain time frame. If a mistake or omission, whether the evidence is redundant or insignificant, is later found, the court often must retroactively add time to the clock. As a result, many cases are dismissed when the clock retroactively runs out. This creates a natural incentive to delay pointing out errors and means insignificant pieces of evidence can result in cases getting dismissed. This has caused a rapid rise in dismissals for small, technical reasons, meaning victims aren't getting justice, and the revolving doors of our court system go round and round. For example, in a rape case, the prosecutor realized that 6 text messages between the previous prosecutor and the victim had inadvertently not been provided to the defense and disclosed them immediately. The evidence was deemed incomplete, and the case was dismissed. In an assault case where the defendant was charged for punching the victim in the face, kicking her, and spitting on her in front of their child, the defense challenged completeness of evidence because of an irrelevant and duplicative piece of paperwork that the prosecution, in good faith, believed was not required to be turned over. The evidence was deemed incomplete, and the case was dismissed. To fix this, the governor is proposing that penalties should correspond with how significant the error is. For example, if the missing evidence is important enough and the failure to turn it over has prejudiced the defendant enough, the judge can still dismiss the case. But for smaller errors, the judge can impose smaller penalties that are proportional to the errors themselves. Justice and public safety are at the heart of Governor Hochul's agenda. This proposal is another step forward, not a rollback. It's a set of necessary adjustments to ensure a system that's safer and fairer for all New Yorkers.